This is you. You're sitting at your desk. You upload a video to YouTube. And then, the video gets taken down. Oh no! Wait, what's this? You've been flagged for copyright? How? How is someone who has done this multiple times never gotten flagged, but you do it once and your video gets taken down the instant you upload it? This is a matter of fair use laws. And that, my fellow viewers, is the topic of today's video. So, let's begin with the bare basics of what fair use means and implies. To understand that, we need to go into the root of the subject of which fair use is involved in: copyright. Well, copyright and the laws associated with it are laws originally designed with the intention of protecting creatives, such as myself, from having any of our creative works stolen. Copyright laws in itself is great for anyone who produces their own original, amazing work. However, as time has gone on in the world of creative endeavors, people more and more have been utilizing content from a variety of sources, including copyrighted content, in order to make content of their own. Or maybe you just use something that was created by somebody else. Now, under normal circumstances, one would probably think that this would get you in trouble, or that you would have a being issued at you, but in some cases, it doesn't. Let's dive a little deeper about the basics of copyright law and then move into fair use territory. So, a copyright, as defined by the U.S. Copyright Office on their website, is a type of intellectual property that protects the original works of authorship as soon as the author fixes a work in a tangible form of expression. That is a very legalese way of saying you make something. Why are laws written like this? Can't they just say, don't do A or don't do B? Copyrights are very similar in trademarks, in which your work is intended to be protected by law, but there is a couple of differences between copyright and trademark. The differences are, copyrights are exclusively governed by federal law. Copyrights offer protection mostly to works in tangible form, technology, and other things more personal. Trademarks, on the other hand, are things like brand names, logos, business names, or anything that applies or identifies a company. Copyright is generated automatically upon the creation of the original work, whereas a trademark is established through common use of a mark in the course of business. And copyrights expire after a set period of time, whereas a trademark doesn't expire, providing that the mark continues to be used. In short, both of these here are to protect one's original work, with some very minute differences here. Copywriting is more personal, while trademarks are towards the business end. In the end, both of the things here accomplish the goal of protecting your works from people misusing it and offer a large amount of services that you can use to protect said work. So now that we understand the raw basics of what a copyright is, now we have to ask, what does fair use mean? Well, the thing that people need to understand about copyrights is that they are not absolute and are limited by the fair use doctrine. The definition of fair use is the right to use a copyrighted work under certain conditions without permission of the copyright owner. The doctrine helps prevent a rigid application of copyright law that would stifle the very creativity the law is designed to foster. It allows one to use and build upon prior works in a manner that does not unfairly deprive the copyright owners of the right to control and benefit from their works. The comprehensible way of saying this to 99% of the people watching this is, in a specific set of circumstances, I as a creative or someone who is trying to make something, for whatever reason, am allowed to use copyrighted material to do so under a very specific set of circumstances. And I need to emphasize, a very specific set of circumstances. You can't just go out, take something of somebody's, display it as your own, and then claim fair use. No. That's called piracy. And that's illegal. And I would never condone or allow someone to commit piracy publicly. No. In order for something to fall under fair use, it has to fulfill 4 prerequisites in order to avoid any kind of infringement. The prerequisites are as follows. The use is non-profit or transformative. The work is factual rather than creative. Only a small portion of work is used. This is what most people on the internet fall under. The use will not detract from the copyright owner's revenues. This is the one that everyone breaks. In theory, on paper, as long as you abide by the sections provided here in the clause for fair use, you can use copyrighted works in whatever form of media or medium you are trying to create. Fair use can also be applied on trademarks. Now, of course, fair use is not absolute in its entirety, which, if anyone here does any kind of YouTube development or creations, you know exactly what I mean when I say that. The thing about fair use in copyright law is that there's no hard or fast rules when it comes to deciding on fair use. An example that the textbook on Cyberlaw provides is as follows. A professor attempting to make scanned copies of a textbook to distribute to his students so they do not have to buy copies of the textbook might constitute infringement. If I can stop myself here for a moment, however, I, as a student, consider my bank account. Please break the law for me! On the other hand, consider the use of copyrighted material on the show, such as The Daily Show with Jon Stewart. You know, back in the day when the show was actually entertaining. The usage of such clips on the show likely constitutes fair use, even though it relates to for-profit programming. Another thing that makes fair use not only rather interesting, as well as a complicated ordeal, especially for people in the YouTube scene, is that fair use is very fluid with how it's determined. For one thing, you don't need to fulfill, when making a piece of media, all 4 of the particular sections on fair use. This means you can fulfill only 1 or 2 of them, and you still might be able to claim fair use on whatever content you're making. On the flip side, however, even if you manage to take all the time to satisfy all 4 sections of fair use, you could still find yourself at the receiving end of litigation. On the flip side, somebody could adhere to none of the rules outlined by fair use and never even get spoken to by anyone. Copyright experts often even have difficulty determining what is fair use or not. And if any litigation does happen, it could go on for a very long stretch of time, just like every single open and shut court case that exists. Now that we've kind of broken down what fair use is and the basics of copyright law, let's get to some great examples of the differences of when something is fair use and when something isn't in the marvelous and terrifying world of YouTube. And let's start off this video by highlighting examples from a video I made. This is my YouTube channel. It is complete cringe. The main content of my YouTube channel is I run a freeware program by the name of MMD. It's a 3D animation program by the people who made the Vocaloid software, which is basically a text-to-speech program specifically made for singing. And if you don't know who Vocaloid is, they're the guys who have this anime as their mascot. What the fuck? Anyway.
Holy shit, he's dead!
Anyway, the program is primarily used by people to make 3D models to sing and animate their movements to music. I, on the other hand, throw all of that out the window and use it to make funny videos. This video right here was an older one that I made, probably when I first started. We're going to play a small segment of the video to demonstrate this. Let's pause the video. Notice that soundbite that was used? Now, the soundbite used by this specific character when she was a little angry at her boyfriend wasn't something found online or in public domain. It's actually a 2-3 second loop of the intro of the song from Bullet for My Valentine's Her Voice Resides. Technically, this is a piece of copyrighted music that I am using in this particular video. However, this would, to my understanding, fall under the purview of fair use. It fulfills not only the first section, but also the third section. The first section of fair use stating that I am using it in a transformative manner. I'm not using it to have any kind of background music playing as much as I am trying to amplify a scene with humorous intent. Another thing is the length of time and the amount of the copyrighted medium that I have used. I only really used 2 seconds of the intro. Considering the length of time of the material used, I think it would be rather silly to say that somebody would want to pursue legal action towards me for a paltry 2-second usage. And it's also probably not within their financial interest to go after me anyway. But that, ladies and gentlemen, is one example of a fair use clause. Let's see another fine example here of fair use, this time in a more transformative manner. The YouTuber that we are seeing here is known as Little V. He's a musician that takes a lot of video game music and creates more metal renditions of it. If I could take a moment to pause the video here, here's an interesting fact about YouTube content creation for people that might be concerned with the legality of such. So YouTube has a botted system in place to where if they hear music that is licensed, such as Billy Joel's "We Didn't Start the Fire" or other excerpts of music, the video in question automatically gets flagged. However, when it comes to music used from video games, they more often than not do not get flagged, or a strike is never usually given on the video owner. Why is that? Well, I later find out that most companies, barring some notable exceptions, prefer to have their music publicly available online. The reason is obvious. Promotion! Most companies would prefer you listening to their game music because it might encourage you to buy the game. Just ask my friend who plays Guilty Gear Strive.
I beat it again! Suck my big bitch!
It was completely about the soundtrack. Yeah, I can't tell you how many times that I've heard, "Man, I can't believe this $60 soundtrack came with a free game." I've heard that a lot. But anyway, for the most part, you don't get flagged for copyright strikes when it comes to video game music in like 90% of cases, if the music is from a video game. That's not saying that they can't come after you. That's just saying that they're more than likely not going to come after you. Anyway, so let's give an example of how Little V takes a form of work and makes it transformative. So here's an excerpt of one of the songs from the game Metal Gear Rising. And if you know what Metal Gear Rising is, you probably know what this song is. And this is Little V's version. This, given that it is being used in a transformative manner, should be protected under fair use. At the time of writing this script, I have now come to realize that he also makes metal versions of real songs, such as this one, and the video hasn't been flagged. So I'm just going to assume that this right here is a definite example of fair use. So we showed a lot of cases where fair use works. What about examples where fair use doesn't work? Well, for one thing, it's a little hard to show these on the screen because, well, you know, they're gone. But there are some examples that we can showcase here on what happens when you don't try to keep things in line with fair use. For example, taking a YouTube account and then uploading every single episode of King of the Hill on it so that people can watch for free is not fair use. There's nothing transformative, there's nothing interesting, it doesn't fall under any of these 4 clauses. In fact, it technically gets disqualified under this clause right here. Music is a great example because you can see the effects right away when you don't even attempt to follow the 4 sections. As mentioned before, YouTube has a system in place where if it detects a piece of music in a video or whatever, it will automatically flag the video. So if you made something and you get flagged, well, kiss all the money that you were going to make from that goodbye. In most cases, the video will still stay up, but there is always that risk that they can issue a copyright strike and then it's gone. But there are some cases where more action is dealt with than just a simple flag. And this year, our favorite lovable company, Nintendo, took all of this one step further and issued a copyright strike on a channel itself. The result of this was an entire channel losing about 500 videos worth of content. Not particularly the best way of engaging with your audience or fandom, but you know, that's just me saying right there. But to be fair, it is within their legal right to do so. In conclusion, copyright and trademarks are very important because they do protect creators' intellectual property from theft. If we didn't have these laws, people would be copying each other en masse, and well, we kind of already do that. But at least we're not doing it so blatantly. Okay, so maybe sometimes we do it blatantly. But at least with a lot of people, they attempt to change the concept and transform it to become its own thing. Either way, the laws are important to protect our intellectual rights. But for those of us seeking to create our own thing, perhaps inspired by or even derived from something we love, we also have our own protections under the law. And after all, most innovation requires a fundamental base to begin with.